The U.S. Department of Justice published the first large batch of documents from its long-awaited Epstein records, as required by the Epstein Files Transparency Act, a law passed by Congress forcing the release of unclassified materials related to convicted sex offender Jeffrey Epstein and his co-conspirator Ghislaine Maxwell. The law set a statutory deadline and included provisions for limited redactions, but the initial release contained thousands of pages with extensive blacked-out sections. The U.S. Department of Justice's public statement on the documents underscores three primary legal justifications for redactions, all of which are grounded in existing federal privacy and procedural rules. First, materials identifying victims or their families have been redacted to comply with protections for individuals who were sexually exploited as minors or otherwise involved in the case. Department officials reported that over 1,200 victims and relatives were identified in the files, and any information that could reveal their identities was withheld from the public upload. Second, some content was redacted under ongoing investigation and grand jury secrecy rules. The law that compelled the release explicitly allows the DOJ to withhold or redact material that might jeopardize active federal investigations or prosecutions, provided the withholding is narrowly tailored and temporary. Portions of grand jury transcripts and certain investigative records are subject to long-standing secrecy protections under federal court rules, unless a judge authorizes their disclosure. Third, a broad category of redactions reflects standard legal constraints on sensitive personal information beyond victim identities. These include dates of birth, social security numbers, other personally identifiable information, and any material that might inadvertently disclose private data about individuals who are not charged with a crime. Federal disclosure laws routinely mandate such redactions in document releases. The Justice Department publicly stated that these limitations are not intended to shield public figures or political officials from scrutiny, and that redactions are being applied strictly according to law. DOJ leadership also acknowledged that the files are being released on a rolling basis, meaning additional material will be published after further review, because of the sheer volume of documents and required legal review. Despite these official explanations, lawmakers from both major parties have raised concerns about the extent of the redactions and the DOJ's approach to the release. Democratic Rep. Ro Khanna, one of the authors of the transparency law, has stated that the statute requires the department to justify every redaction in writing, an obligation that had not been publicly fulfilled as of the first release. Republican Rep. Thomas Massie, who co-sponsored the law, said the initial set of documents grossly fails to comply with both the spirit and the letter of the law. Senate Democrats, including Minority Leader Schumer, have similarly demanded explanations for why entire documents, in some cases exceeding 100 pages, were released with no unredacted content. These legislators assert the law's language calls for comprehensive disclosure of unclassified material, subject only to narrow exceptions, and they are reviewing legal options to compel full compliance. The context of this release also carries a political dimension. President Donald Trump signed the Epstein Files Transparency Act into law after months of public pressure and initial resistance to making internal investigative material public. Critics note that the first tranche of released material contains few references to Trump himself, while some files include images or records involving other high-profile figures. This discrepancy has led to questions about whether the redaction process is being applied consistently or influenced by considerations beyond the statutory exemptions. DOJ officials have rejected claims that political considerations are shaping the redactions, emphasizing that the department is following statutory requirements and long-standing legal standards for privacy, grand jury secrecy, and ongoing investigations. They have also said they will provide Congress with detailed lists of released and withheld records, as required by the transparency law. In summary, the redactions in the initial Epstein file release are rooted in three main legal categories: victim privacy, grand jury and investigation secrecy rules, and sensitive personal information protections. The decisions reflect federal disclosure norms, but the scale of blackouts and the missed statutory deadline have prompted bipartisan scrutiny, leaving the public and lawmakers awaiting further documents and formal explanations for the redactions applied.